Good afternoon. My name is Will Marie Newton, and I'd like to thank you for joining us for today's webinar. Please note that this webinar is being recorded and will be archived on CABE's website under Professional Development. It will also be emailed to everyone who registered. And now I'd like to introduce Lisa Steimer, Executive Director for CABE.
Thanks so much, Will Marie, and good afternoon, everyone. It's wonderful to have you with us today, and it's particularly wonderful to have Russell Blair with us today to do a presentation on FOI. Russell is Director of Education and Communications for the Freedom of Information Commission, managing training programs as well as answering questions from state and local officials, journalists, and members of the public about all things FOI. Before joining the FOIC, Russell spent more than a decade working in local journalism for the Record Journal in Meriden and the Hartford Courant. Russell has presented at the CABE CAPS convention, so he may be familiar to some of you, as well as presenting to a meeting of the Superintendent's Administrative Professionals recently. A graduate of UConn with a double major in journalism and political science, Russell is a lifelong Connecticut resident who now resides in Manchester. So Russell, welcome. It's wonderful to have you with us today, and I turn the presentation over to you.
Thank you so much for the introduction. It's great to be here. I've got my presentation, so I'm going to share my screen. While I'm getting that all set up, a couple of things I just want to mention. First is I'll save some time at the end for Q&A, but also if people have questions as we're going, I find the easiest way to do that is if you drop those in the chat. I will try to keep an eye on the chat and see if I can address things as we're going. And then at the end, we'll save some time for, questions if people want to come off the mic and ask it that way as well. I should mention, particularly pertaining to boards of education, you heard my introduction, my background is in journalism, local journalism, and really my first assignment was covering school boards. I was at many a Wallingford Board of Education meeting quite late into the evening, covering budgets and curriculum and all that kind of stuff. So I am very familiar, with the workings of school boards, from that angle, but still learning more every day as I talk to people about the issues that are arising. So I say this sort of half jokingly, but it might end up being true. The most important thing you might learn today is my contact information, my email, my phone number. Feel free to reach out in the future if there's anything that comes up. I don't want this just to be today an opportunity. I want that invitation to be open. If you have something that arises, even if it's something that, hey, I think this is the right thing to do, but we just want that verification, I'm happy to assist with those questions or queries, or even if it's something that, you're not sure what to do, give us a call and we can always talk through it. So always, make myself available if people have questions. Just very briefly, whenever I do these presentations, I also like to talk a little bit about the history of the Freedom of Information Act and, just to sort of get us in the mindset of why we have this law and, what it does and what the intention of the law is. So the FOI Act goes back to 1975. So, if you're good at math, you recognize we're celebrating this year the 50th anniversary of the passage of the FOI law. Governor Ella Grasso was the governor at the time. She was a real champion of the Freedom of Information Act. And really, it's about government transparency. It is about, holding our meetings in public. It is about making our records available to the public. Essentially, it's saying, look, we want government to operate out in the sunlight. We want people to be able to come to meetings, to hear discussions, to see decisions being made, and also to have access to information in terms of records so that they can understand the decisions that their school district is making. We are right in the middle of the budget season, right now in most cities and towns. That's in most towns, the majority of tax dollars go to school districts. So I think people are really interested in what's happening with the schools and where the money's being spent and what programs are being offered. So the law, allows people to be able to get some insight into that process, through attending meetings, or through making records requests. And one other important thing, about the law, I'd be remiss if I didn't mention it, is that the law also created the FOI Commission where I work. And if you're not familiar with the FOI commission, maybe that's a good thing. Maybe it means that, you haven't faced any complaints recently or anything like that. But what we what we do as a commission is we adjudicate disputes that arise about FOI issues. So if somebody believes that something, has gone wrong with a public meeting, the agenda wasn't posted properly, or maybe they think the board went into executive session when they shouldn't have, or if they make a records request and they feel that they don't get all the records that they're entitled to, or they feel that the response time is taking too long, anything like that, a meeting or a records issue, they can file a complaint with our commission. And then we have a process where we adjudicate those complaints. We have the ability to hold hearings if necessary. We can order public agencies to submit records to us for us to review and determine, what should be released. So we have different tools that we can use to make sure that folks are following the law appropriately. So just some basics about the FOI law. There's two parts of the law, meetings and records. We're going to mostly focus today on meetings. As I understand, there's a lot of Board of Education members on here and people who work with them and help with their meetings. We'll touch a little bit on records too toward the end, but if anybody has any questions about either, happy to take them at the end there. So a couple of things, dealing with the FOI law and what it covers and what it doesn't cover. The first is dealing with records requests, and I just think it's important at the onset for everyone to understand. An FOI request is really a request for records that you have, that you keep, that you maintain, that reflect the business of your agency. It is not a obligation that you have to do research or create documents that don't already exist or even answer questions. Somebody can make a records request for budget documents. If they send you an email and say, why did you think it was a good idea to spend this amount of money on this? You may want to answer that, or you may not, or, you may address it at a meeting or whatever you want to do. But a list of questions is not an FOI request. A request to create a new document that doesn't exist. I want you to create me a custom report that shows this. Those are not FOI requests. An FOI request would be, I would like a copy of the curriculum that's being used in this class. I would like, the bills from the HVAC company that just installed the new system at the elementary school. Those are FOI requests, emails, financial information, personnel records, whatever it may be, if somebody wants to make a request. So when it pertains to public meetings, one thing I think is important to mention too is that the law is not about participating and speaking at meetings. The law is about attending meetings. So the law gives anyone the right to attend a public meeting. Whether or not you have public comment is up to you, and that means that you can have rules for public comment that you wouldn't otherwise have for people attending. What that means is you could ask somebody to identify themselves, state your name and address. That's a very common thing. If somebody wants to speak at a school board meeting, you could also limit their comments. You get 2 minutes or 3 minutes. Or you could ask people only to discuss items that are on the agenda. Whatever you want to do with public comment is your business. You can offer it, you cannot offer it. That's your decision to make. And there's no violation of the FOI law or any other state law if you don't have public comment at your meetings. The FOI Commission, we already talked a little bit about that. What we do, we settle disputes that arise. If somebody believes that agencies are not following the FOI law, what different powers do we have? Well, we can require a public agency to produce records to a requester. We can order mandatory FOI trainings. We can issue fines. This one is really important for to be aware of, is that we do have the ability to nullify votes that were taken at a meeting if we determine, something wasn't done properly. We don't do that too often. That is a big step for us to come in and nullify a vote, but that is something that, should be on your mind as you're thinking about all this in terms of potential ramifications. With fines too, we don't do that all that often as well. But if there was a situation where, we felt like some behavior was really egregious, we can issue fines. And the legislature recently raised that authority. So the maximum fine for a violation could be as high as $5,000. Just very briefly, what is a public agency? I mostly include this because I tend to use that term a lot, agency or public agency. And you may be wondering, what does it mean? Well, it's really just what the law refers to as anybody who's covered under FOI. So a school district is a public agency, a board of education is a public agency. If you have any subcommittees, you see in bold there, it says including any committee of or created by. That's one thing to keep in mind too. So if your board has, a curriculum committee or a building committee or a personnel committee, all those committees that your board creates, Those are also, entities that are covered under the FOI. And it could also be a committee that, the administration creates in some circumstances, the superintendent might create a certain committee to carry out a certain function. And that committee might also be a public agency, if it's an extension of the work that the school district is doing. So generally, the FOI law only applies to, public entities. There are some, off cases where a nonprofit or a business or something might get pulled in. It's rare, but the big example is Woodstock Academy, which if you're from that part of the state, you might be familiar with. It's a private school, but because it serves as a public school for students in that corner of the state, they are governed by FOI laws. All right, so as I said, we'll start with the meetings piece of the law. If anyone has any questions as we're going, we'll drop them in the chat, and also I'll save a few minutes at the end when we get close to one for people who want to ask questions from their microphones as well. Hopefully, when you have a meeting, you're not sitting here like these folks and trying to figure out why we're having this meeting. But with the meetings part of the FOI law, the first thing I always like to look at is the definition of a public meeting. And this is important for a number of reasons. I think the first is that it's important we all understand what it means when we say a meeting. A meeting is not every single gathering of people on the Board of Education. It's not every single gathering of people who are talking about school business. There is a specific definition of what is a meeting under FOI. And the reason that's important is because if you're going to hold a public meeting, we need to notify the public of when the meeting is going to take place. We have to file an agenda of what we're going to discuss. That meeting needs to be open to the public, and then we have to produce minutes. So if it's a public meeting, we have to do all of that. If it's not a public meeting, we don't have to do all of that. So it's important to know, what is a meeting and what isn't a meeting. The way that I try to explain it, I've found the easiest way to try to explain it is that there's really kind of three things. And if all three of those things are happening, then, you're at a meeting and there should have been an agenda and it should be open to the public and so on. So the first is, you see in bold there, convening or assembly of a quorum of a multi-member public agency. Quorum is really, really important. Now, there are some instances where there might be a proceeding that is a, public meeting, but a quorum of board members are not there, but they're really kind of few and far between. One example, I give is like a Board of Assessment Appeals. If any of you have, gone to your town to appeal your valuation for your taxes, there might be one board member that will hear your appeal. That is still an open public session, even though a quorum isn't there, because that is, considered a hearing or a proceeding. At the FOI Commission, if you have an FOI hearing, those are before one attorney who acts as a hearing officer for the commission. Those are open public meetings. But generally, for most cases, the first thing is a quorum. So if you don't have a quorum of your board members, it's probably not a meeting under FOI. For anyone who's unfamiliar, quorum is a voting majority of the people who are seated on the board. You don't count the vacancies. So, if you have 7 active members of your board, then, 4 members would be your quorum. So the first thing is a quorum of board members. The second part is that they're either gathered or they're communicating back and forth in person or by means of electronic equipment. So what that means is a meeting doesn't just mean, we got together at the Board of Ed conference room, we sat around the table and we talked. A meeting could be, under this definition, held over email. A meeting could be held over text message, could be held over the phone, over Teams, over Zoom. If you have a quorum of board members, they're gathered together and they're talking, and the last part, to discuss or act upon a matter over which the public agency has supervision, control, jurisdiction, or advisory power. So you're discussing board business. Those are the three things. A quorum, they're gathered or communicating in person or electronically, and it's dealing with board business. If you have those three things happening, then I would argue that is a public meeting under FOI. So what that means, and this is the thing everyone needs to be aware of, is you want to avoid situations where you're having discussions of board business over email, if you're having discussions of board business over text message, because if a quorum of your board is on those communications, now you're having a meeting, and obviously if it's in your text messages or it's on your email, it is not a public meeting, right? The public is not in your email inbox with you seeing those discussions. So, generally, if you just keep that in mind, And you remember that really the intention of the FOI Act is that you discuss your board business in public at your public meetings. Now, if one or two members, or two or three members, depending on the size of the board, if a couple people want to gather between meetings or before a meeting and they want to talk about something, if they're not a quorum of the board, they can do that. Or if a member of the board has questions and they want to contact the superintendent, hey, before we vote on this, I have some questions I would like answered. Or they have other staff members, they want to talk to the principal about something. They can do all that. It's not meant to prohibit communication. It's not meant to prohibit people from gathering information before they make a decision. It's really about when it comes time to discuss or act upon something. And I think that bears repeating, discuss or act. So you could have a meeting without taking any votes. It's not just about voting on things. When it comes time for the back and forth discussion among the board members, then that needs to be happening at a public meeting. We have a question in the chat. What if less than a quorum, 2 to 3 board members, but it is a board subcommittee and it is meeting in public to discuss board matters? Is this still considered a meeting? So yes, if you're going to have a subcommittee, if it's going to be, let me try to think of the best way to say this. So yeah, subcommittee meetings need to be noticed, need agendas, minutes, and so on. The thing with subcommittees that can get a little bit tricky is, if you have board members who get, designated to a certain subcommittee, and you have, let's say, those 3 members who all happen to be on the same subcommittee want to discuss something, well, no, they're not a quorum of the full board, but that is a quorum of that particular subcommittee. So with subcommittees, you just need to be mindful of who is on what subcommittee and what they're talking about, but you wouldn't want to conduct, subcommittee business outside of a public meeting if you had a quorum of that particular, subcommittee there as well. Hopefully that answered that question, but we can talk about it, at the end again if we need to. But yeah, just be mindful. Subcommittee meetings, yes, need to be noticed. They should be treated the same as your full board meetings in terms of agendas and minutes and so on. So again, save the back and forth debate for your meeting, and you'll be in good shape. A couple other things just to consider. The first is, we mentioned earlier about how you can set your own rules for public comment. However, like people might have to identify themselves, but people don't have to identify themselves to attend a meeting, and that is in person or electronically. This has come up a little bit more often now in Zoom. People have asked me, what if somebody calls into our meeting and they don't identify themselves and all we see is the phone number and we don't know who it is? It's a public meeting, so it really doesn't matter. It's just the same that, if you had an in-person meeting and somebody wandered in and sat in the back of the room, and they didn't want to say who they were, they don't have to do that. So in person or online, if somebody doesn't identify themselves, that alone would not be a reason to exclude them from a meeting. Agendas need to fairly apprise the public of what will be discussed at the meeting. We'll talk about that more in a second. And anybody can photograph, record, or broadcast a public meeting. So, I mentioned this, when I'm doing my presentations, and I say I hope nobody would do anything at a public meeting they wouldn't want recorded, but just keep that in mind. People don't have to, seek prior permission. Once the public meeting begins, anybody in the audience can take out a tape recorder, they can take out their iPhone, and they can record what happens in that meeting. Email and meetings, we already kind of talked about this. So, it's okay to use email with your full board if it's administrative matters. Somebody wants to propose that something be added to the agenda. Somebody wants to, schedule a special meeting and you need to, check members' availability. A one-way communication is also okay. If the superintendent, that something happens at the school, this is probably pretty common. And the superintendent may send a notice to all the Board of Ed members, hey, just so you understand, this is what happened, this is what we did with this, or here's a copy of, a letter that was sent home to parents. I just want you to be aware of this. It's really the back and forth discussion. So it is not about just the sending of an email to everybody and that triggering an illegal meeting. It's when people start to reply and start to, discuss issues that they should be discussing in a Board of Ed meeting. In the corporate world, if anybody's in the corporate world, people always groan, oh my God, why do we have this meeting? It could have been an email. In FOI world, it's sort of the opposite of, oh my God, why did they send that email? It should have been a meeting. So just be careful of that. A couple questions in the chat. Can anyone, parents or community members, attend any committee or subcommittee meeting? Yes, if it's a public meeting, then it is open to the public. Anybody who wants to attend. whether or not they have any ties to the school district or anything, it doesn't matter. PTO meetings would not be subject to FOIA. PTOs are, those are, yeah, I don't know actually what they are, if they're nonprofits or whatever organizations they are, but they are not, their meetings are not covered under FOI. However, the one thing just to be aware of as board members is that if a quorum of board members attended a PTO meeting and they started discussing things that were going on at the Board of Ed, that would be an issue, and that could be, it wouldn't be a violation against the PTO, but it would be a violation against the Board of Ed. So what I have said is, look, if one member of the Board of Ed wants to go to a PTO meeting and give an update or something like that, that's fine. But if, the whole Board of Ed wants to have a discussion with the PTO, I would say invite the PTO to come to one of your meetings, and then you can have a full discussion at the public meeting with the PTO people that you want to talk to. Can parents speak, give opinions at these meetings? As I said, public comment is not required, so it's up to the board how they do that. They don't have to have public comment at their meetings, but certainly if they have public comment, then anybody who wants to go to the meeting would be allowed to speak, subject to whatever the rules are for public comment. Okay.
Russell,
Yes.
I'd like to draw your attention to the Q&A at the bottom of your screen. We've got some questions there as well.
Oh, okay. Thank you. I didn't see that. So somebody asked, is a teachers union considered a public agency, or does that fall under FOIA? So unions are not considered public agencies under FOIA. However, any interactions that they have with the district, those records are public. So like if somebody files a grievance, and the district gets a copy, or if there's communications between, the administration and the union, somebody could, ask for copies of those from the administration. Somebody also asked about committee meetings below a quorum and discussing but do not act upon matters of interest. I think so. If it's a standing, I think the difference with the committees and the working groups, people use different terms. What I would say is if it is a committee that you've created and you've assigned people to it, then those meetings need to be open to the public. If it's a situation where a couple of board members are, gathering together, I think that's a little bit different. I think if you have a personnel subcommittee, I would say that should follow FOIA. Now there are certain things that could be done in executive session. So it may be that it is a public meeting and a lot of the discussions are going to be held in executive session. But, if you have a standing personnel subcommittee and there's people that are on that committee and it meets regularly, then I think those meetings would need to be held in accordance with FOI. Do you still post subcommittee meetings that are closed, such as the negotiations committee? We'll get to this in a second because I think this is maybe where this falls in. There is a carve out to some of the meetings provisions, and there is one that deals with collective bargaining. So if it is a collective bargaining strategy session, then those don't need to be noticed as public meetings. So, if you had a situation where, this negotiations committee, if that's what they were doing, if they were meeting with the union president and it was strictly, strategy and negotiation session for collective bargaining, that would not be a public meeting. But if that committee, for example, had to vote to make a recommendation on a contract to the full board or something, that would need to be done in public. Or with the personnel subcommittee, if they were going to make a vote to, recommend somebody for the superintendent's position or whatever it may be. So with those kind of committees, there might be some work that they could do in executive session or maybe outside of FOIA if it pertains to collective bargaining. But I would imagine most of those meetings and most of the work they do, they're going to require notice, even if some of that is done in executive session. If the personnel is discussing salary or stipends, those would also need to be. We can talk about that in a maybe we'll go through the some of the things with the meetings, and then we could touch on that a little bit. At the end, because you can go into executive session to discuss personnel matters. So I'll go through that with executive session. I think that might answer your questions. There are some times when that can be done in public, but also sometimes when it is not done in public. A grievance hearing, there actually is, this has come up before at the commission. And if you want to connect with me offline, I could probably send you this because I don't have it at my fingertips, but There is with grievance hearings, it's kind of a two-part process. And there is like the evidentiary portion is done in public, but then there's the ability to have some of the discussions after that, when there's deliberations about what decision is going to be made in an executive session. So it's a little bit of, sort of half and half, with those grievances. But I don't want to, there is a statute and decisions that deal with that. So if you want to send me an email, or give me a call, I can dig that up. I just don't have it at my fingertips. Do changes to an administrative contract need to be discussed by the board in open session? Potentially that could maybe be something that would fall under a personnel matter. However, once they're going to vote on a contract, that would need to be done in public. But we're going to go through executive session. That maybe will help to, answer some of these questions. So we're going to go through, the noticing of meetings, types of meetings, and then executive session. And then if people have other questions after that, I'd be happy to address them. So there's two main kinds of meetings: regular meetings and special meetings. Regular meeting is a meeting that is on your regular meeting schedule. So at the end of last year or the start of this year, hopefully you all did this, filed a regular meeting schedule of your Board of Education meetings. Your subcommittee should do this as well if they want to have regular meetings. If you don't have a regular meeting schedule, then every meeting you call would be a special meeting. A special meeting is just a meeting that is not on that your regular meeting schedule. And there's only really a couple differences between regular meetings and special meetings. You can conduct the same business, just the rules are a little bit different. So for regular meeting notices and agendas, those need to be filed at least 24 hours before the meeting. For special meeting, again, notice an agenda 24 hours in advance, but special meeting notices, you need to make sure that gets posted on the website. I think most boards of education have to, they post most agendas for all their meetings online, but if it's a special meeting, you need to make sure that gets done. Cynthia asked about posting all the materials for regular meetings. That interestingly enough, that is in the education statutes. I'll confess I don't know if it applies to special meetings or not, but what's interesting is that requirement about posting the materials. It's not in the FOI Act. So if somebody doesn't do it, it can't be subject to an FOI complaint. So we don't enforce that provision. So there is a law that talks about posting meeting materials before the meetings, but they didn't put it in the FOI Act, so we can't enforce that. So that's not something somebody can bring a complaint to us about. I don't know if the legislature might change that in the future, but as of right now, it's not something that we have jurisdiction over. So you should post the meeting materials, certainly for regular meetings. I just don't have it in front of me to know if it applies to special meetings as well. Does the 24-hour posting notice include weekends? It does not, in that you have to file the agenda and the notice when when your offices are open. So what that means is if you're going to have a special meeting on a Monday, you need to file that agenda and notice on a Friday. I understand, on the website, you might say, well, we could post it on Sunday, 24 hours before the Monday meeting. However, it wouldn't be filed in your office, and the agenda needs to be, filed in the office and available, and then also posted on the website if it's a special meeting. So Zoom links, we'll get to that as well. So the other differences between regular and special meetings is that at a regular meeting by a 2/3 vote, you can add items to the agenda. We see this a lot of times under new business. Somebody goes around, hey, Mr. Chairman, is there any new business? Yes, as a matter of fact, I'd like to add this item. So by a 2/3 vote at a regular meeting, you can add anything to the agenda. I've got a slide on emergency meetings upcoming, so we'll touch on that too. You guys are good. You guys know all the ins and outs, it seems like. So special meeting, you cannot add items to the agenda. So just keep that in mind if you have a special meeting. My suggestion would be maybe just remove new business because you can't add new business at a special meeting. The other difference, and we'll get more into the content of minutes in a second, but the other difference is that with regular meetings, you get 7 calendar days to have your minutes filed. Special meetings, you have 7 business days. So special meetings, you get a little bit more time to turn your minutes around. And again, really a special meeting is just a change in time. You move the day of the week because there was a snowstorm. You want to move the meeting from 7 o'clock to 5 o'clock. You have to add a meeting, that you meet once a month, but you need a second meeting that month, anything like that when you're modifying the schedule, that would necessitate calling a special meeting. Emergency meetings for Michelle had just asked about this. So there is, in the law, there is a provision that allows for an emergency meeting. And what an emergency meeting is basically it's a special meeting, but there's no notice or agenda required. And that is because, you're supposed to be discussing something that isn't a bona fide emergency matter. And the way to think about this is what our Supreme Court has said is an emergency meeting is only acceptable when it is something where you cannot wait 24 hours to schedule a special meeting. Because if you think about it, we're sitting here today, it's 12:30. If we were in the Board of Ed office, we could file to meet at 1 o'clock tomorrow with a special meeting. So there's a lot of flexibility with special meetings. And particularly with online meetings, there's even more flexibility because now we have Zoom. So we could have a special meeting, it could be entirely remote if we need to get together to talk or vote on something. But if something comes up and, there's a real emergency, maybe it's a weather situation or it's a safety issue or, during COVID, we might have seen this, when you're having to make decisions really quickly about what's going to happen to the schools, you can have an emergency meeting. And again, no notice or agenda is required. You can only consider emergency matters. And then if you have an emergency meeting, you need to turn the minutes around within 72 hours, and they have to be posted online and state the reason for the emergency. So emergency meetings, it's a tool that is available to you. I would just urge caution that, only do this if you really can't wait 24 hours. If there's an emergency, certainly you need to deal with it. But I would just use this sparingly because it's going to draw attention just because it is a little bit unusual in that there's no notice or no agenda. 72 hours from the start of the meeting, 72 hours from the time, I think it would be from when the meeting was I think it would be from when the meeting began, 72 hours from when the meeting began, or when it was, when it started to file the minutes. So as I mentioned earlier, there are some carve-outs to meeting provisions of the FOI law. And the first one, deals with personnel search committees. So this is kind of the only time where you can create a committee that is not covered under FOI. Where we see this most often in boards of education is you might create a superintendent search committee. And in some cases, I've seen the board appoint the entire board as the search committee. So you could do that, and then the board could meet as a search committee outside of public view. It's not an executive session. It's really considered just not to be a meeting. So, again, that's kind of the only subcommittee that's a little bit different is if you create a personnel search committee. But the only thing the personnel search committee can do according to our statute is make a recommendation for an executive level hire. So they don't have the authority to pick, to vote on the person. They can make a recommendation to the board, and then the board would take it up in the normal course of business. Strategy and negotiations related to collective bargaining. So somebody had asked about, about this, I think negotiating committee. They might fall under that, if they are having a session strictly dealing with negotiations for a contract, that might fall outside of the meeting provisions of FOI. Caucuses are not considered meetings under FOI. The one thing to keep in mind with caucuses is that, caucuses need to be members of the same board and the same political party. So it is not, people between boards. So it's not like a Republican on the school board can caucus with the Republicans on the Board of Finance. A caucus is members of the same board and the same party. There are provisions that allow you to have a caucus where not everybody is in the same party. Where that comes up is like you might have somebody who maybe was unaffiliated but ran with one or the other ticket. If that's the case, if you have a majority or a majority caucus that is not just all the same party, the law does talk about filing that caucus with the town clerk and saying, that for the term on the Board of Education, the majority caucus is, 4 Republicans and 1 unaffiliated, member who ran with the Republicans. Does minority representation need to be followed for Board of Education meetings or simply a quorum of the board? I'm not quite sure I understand the question. We have minority representation laws about who can be seated on a particular board. So certainly those need to be followed. I'm just not quite sure how that interacts with the with the quorum piece there. So caucuses are not public meetings as long as we keep it. If all members present for a quorum are all Democrats, can you still have the meeting? Yeah, you could still have a meeting as long as you have a quorum. Yeah, if none of the members of the other party showed up, then you could still proceed. The minority representation laws are about who is elected and seated on the board. So you couldn't have, if you elect at large, you can't have 9 members of the board all being of the same political party. Okay. So other meetings that are not public meetings under FOI, staff meetings, that means again like a meeting, with the superintendent and principals, or meeting with, principal and teachers. Staff meetings are not open to the public. And chance or social meetings. What that means is it just essentially, if there's a situation where a quorum of a board is gathered together, but it's not for the intention of discussing board business. Example of this might be graduation. I imagine that a lot of Board of Ed members go to graduation. You might have the whole Board of Ed at graduation. That's okay. They can go there. They can support the students, but they should not be there conducting board business. So, the other example I give is, the high school football game. You might have a lot of board members that want to go support the team. That's fine, but they should not be sitting in the bleachers and, discussing the budget while they're watching the game. We have a question here. If members of the Board of Ed are attending the Board of Finance meeting to present the budget, and there is a quorum of the Board of Ed, but no action is expected, only 2 members are presenting, but 2 of the other 3 members are there to watch, do we have to notice that meeting, or can it just be a Board of Finance meeting? So if the board is participating in another public meeting that has been noticed, then that's okay. If they're on the agenda at the Board of Finance meeting, then certainly they can go and they can, discuss things because it's a public meeting and they're on the agenda. Some cases, depending on what's happening, people will notice those as like a joint meeting if it's more of a collaborative discussion. But, if this is like a budget workshop situation and, you guys are appearing and then the police chief is appearing and then the public works director is appearing, I think that would be proper, because it's all taking place at a public meeting. And certainly members can attend any public meeting, even if it's a quorum. That doesn't become an issue. Where it becomes an issue is, if they're attending, if they're not on the agenda, they should not be, sort of responding from the audience or getting into a back and forth with the members or something like that. So generally, if they're going to participate in a public meeting, that's okay because it's being done in public. It's just the agenda needs to make it clear. So if somebody's following the Board of Ed, they understand that I might want to go to this Board of Finance meeting because the Board of Ed people are going to be there. So in that case, I think just make the agenda clear that it's going to be a presentation on the budget from the Board of Ed. And I think that would be okay. Okay, electronic and remote meetings. Excuse me. So sometimes people ask about, do we have to have electronic access to our meetings? And the answer to that is no, you don't have to have electronic access to your meetings. So it's your choice. However, board members always have the option to participate remotely. So what that means is you can have an in-person meeting and you could have board members call in on the phone. You could have board members Zoom in, whatever you want to do, that's okay. But the type of meeting you have is up to you. If you want to have an electronic meeting, somebody had asked about this with the Zoom link. There is a requirement that 48 hours before the meeting, you need to have available to the public somewhere posted that the meeting is going to be held with an electronic access, and then the instructions on how they can attend the meeting. So the instructions are usually just going to be the link or the dial in or whatever they need to do to get onto the Zoom. The agenda is still 24 hours. So even if we meet on Zoom, the agenda can still come 24 hours. But if we have a regular meeting on either all on Zoom or hybrid, then the link needs to be out there 48 hours ahead of time. So as long as you do that, you'll be okay. Some cases you might be able to do the agenda with the link and all together 48 hours before. That would be probably the easiest. But if you're still working on the agenda, at the very least, make sure the link gets out there. That only applies to regular meetings. If you want to have a special meeting, electronic access, then it's treated the same as a special meeting in person. Just make sure you put the link on the agenda when it goes out 24 hours before the meeting. People sometimes ask about recording of meetings. The only meetings that you have to record are meetings that are online only. So if you have and regular. So if you have a regular Board of Education meeting, or maybe it's a subcommittee, might be more common at a subcommittee level. But a regular meeting of your board or your subcommittee, and there's only electronic access, you want to make sure you record those meetings, post the recording on your website within 7 days, and have it available on your website for at least 45 days after that. So those are the only meetings that have to be recorded. If you want to record other meetings, that's up to you. You don't have to do it. I will say, I think a lot of people got used to it during COVID. So if you can keep it up, I think that's a good thing, because I think a lot of people like to either be able to watch it after the fact, or they can follow along from home if they're not able to make it out. So it's not to say you might not want to record more meetings, but it's not required other than the online only meetings. You still do minutes even if you record the meeting. Now, if you have a full recording, the minutes might be shorter. And we'll talk more about minutes, in a second. But you still do minutes even if a recording is available. And online participants can be kicked out of a meeting if they're being disruptive if it's an online meeting. I just mentioned that because early on we saw a lot of Zoom bombing at public meetings. I think it's kind of tapered off. Maybe Zoom has gotten better at security. But if somebody is not behaving appropriately, or they're saying things in the chat that are not appropriate, then you could kick somebody out of a meeting or mute them or whatever you need to do to retain control. Alyssa asks, we allow each citizen who wants to make public comment going no longer than 3 minutes. When you say disruptive, would that cover someone who is online trying to do multiple comments? I think it depends on the behavior, but usually what I tell people is if somebody's violating the rules, give them a warning. I wouldn't automatically just go to kick them out. But for example, if you have a situation where somebody's 3 minutes are up and they continue to talk and they won't mute themselves and they're talking over people, and you've warned them and say, hey, your time has expired, please mute yourself. And I don't know, you can't mute them, through your access, maybe something like that. If they were really being disruptive and they wouldn't let the board continue their business, then that might be a reason to, remove somebody. But generally, I would say give them a warning, try to see if they'll correct their behavior. But the point is, if somebody's, putting racist things in a chat, or they're taking over the presentation or whatever it is, those sorts of things, you don't have to stand for that. Sometimes people do things online they wouldn't do in person because there's more anonymity. They might think people can't find out who they are. I just make that point to say that you don't have to stand for that. It is a public meeting. There's a certain level of decorum that is required. For the online only meeting, does that need to be video recorded, or can it be audio of the video? So it needs to be either a full transcript or a video recording. So if you do have a transcript, you could do that in lieu of the video, but I think video is probably easiest, and a lot of platforms have an option to do that. Minutes, somebody had asked about. We'll cover the minutes in a second, so I'm just going to hold on that. So executive session, and then next we'll talk about minutes. Is there a list of sample committees or subcommittees that would definitely be open to the public? For example, wellness, transportation, school readiness, or building committees. I would err on the side of I think pretty much all committees are going to be open to the public. If it's a committee that you create out of the Board of Education, regardless of the subject matter, if the Board of Education, one way to think of it is, if the Board of Education is covered by FOI and you are going to delegate some of your authority to a subcommittee, you can't delegate away your FOI obligation. That's the reason the language is in there about committees of and created by. Is when the FOI law was being developed, they didn't want people to say, well, the Board of Ed is covered, but what if we create this other group and now they're going to do all the work, but nobody knows what's happening at that level. Online subcommittee meetings must be recorded as well. Yes, if it's a regular meeting of a subcommittee, then it would need to be recorded. I know a lot of times subcommittees might meet online because it might be a smaller group. It might be easier to do it that way. So yes, if it is a regular meeting of any public agency, full Board of Ed, subcommittee, town council, whatever, any regular meeting conducted entirely remotely has to be recorded. Okay, executive session. So with executive session, where I find that people get in trouble, I should step back and say that I think of all the meetings complaints we get, this is probably the number one issue for a couple of reasons. One, it requires the most judgment, and it's hard sometimes to figure out, if something's appropriate for executive session or not. And two, you're excluding the public. So chances are this is something somebody's going to complain about if they think that you didn't do it right. I find that if you stick to what the statute says, you should be okay. Where people get in trouble is when they try to get creative and try to fit things into executive sessions that don't really fit very well. So the reasons to have an executive session, and then we'll go through some of the things you want to make sure you do if you're going to have an executive session. The first reason to have an executive session is you can discuss personnel matters in an executive session. And what specifically personnel matters means is under the law, it says, you can discuss the appointment, employment, performance, health, evaluation, or dismissal of a public officer or a public employee. So somebody had asked about a Board of Education going into executive session for self-evaluation. So because Board of Education members are public officers, you can go into executive session to discuss issues involving Board of Education members. The commission has had a case where we have said if you want to have an executive session to talk about interpersonal things that are going on with the board members, you could do that in executive session, but it really needs to be, it's kind of like threading the needle at 30,000 feet or, whatever it is that they say. You want to be careful about that because if people on the board are not getting along and there's interpersonal things going on, you could have an executive session to try to iron out the interpersonal issues. Or, if you had a board member who was being a real jerk to everybody else and you wanted to try to discuss that or take action against the board member or whatever, you could do that in an executive session. But the discussion would need to be based on really strictly just kind of those interpersonal, everybody getting along type of things, not about actions that the board might take. So I think you could have an executive session to do some self-evaluation, but you really need to make sure that you're not getting into other things in that discussion. And that's hard because once you go in, you don't know where the discussion is going to turn. So I think there is a limited ability to do some of that, but you need to be careful. And if the person who asked that was interested, you could email me and I could send you the decision where we dealt with this so you can kind of see what we consider to be appropriate and kind of where that line is. The other thing to mention too with personnel matters is that you need to notify the individual who's being discussed. So if you're going to do your superintendent's evaluation, you notify the superintendent and you're saying, hey, we're going to do your evaluation at the next meeting in executive session. Because the reason for that is the person who is the subject of the executive session, it's not really a request. I should use a different term there because they can say, I want that done in public. And if that's the case, then it has to be done in public. I think I actually saw this come up recently. There was not picking on the district, but I think it was Waterbury. There was an article about a principal that was dismissed from I think it was like an alternative high school. And she had made that request that, hey, if you're going to dismiss me, I want this discussed in public. So her issue was discussed in public at a Board of Education meeting because she asked for that. So with personnel matters, if somebody's going to be in executive session, notify them ahead of time, and then they have the right to request an open session if they wish. You can go into executive session to discuss pending claims or litigation. That one is pretty straightforward. Lawsuits, CHRO complaints, FOI complaints. Needs to be something that has either been filed or it's imminent. You've received a letter, threatening a lawsuit or something that would also be appropriate as a pending claim. Security matters, if a discussion of the matter, would reveal security secrets or you're concerned about the, attention to it. We saw this a lot, unfortunately, after Sandy Hook. Schools were doing a lot of review and evaluation of security measures. You could do a lot of that in executive session if it deals with specific security issues. Sale or lease of property. This is before an offer is being made. If there's concern that publicity would impact the price point, it's kind of similar to the security one. Maybe, the Board of Education wants to build a new athletic complex. There's a piece of land that's been vacant on the market for a while. They want to put an offer in. They would have the ability to discuss some of that in executive session before they put the offer in so as not to tip off, somebody else in town from coming in and bidding up the price on that property. And then you can discuss any records that are exempt from FOIA in an executive session. This comes up a lot in, the context of if you're talking about anything that is protected by FERPA, student discipline or things involving individual students, you can go into an executive session to talk about those matters. We don't have time to talk about all the FOI exemptions, but basically if it's a record that you wouldn't disclose under FOI, you can discuss and review those records in executive session. If you want to have an executive session, you need a 2/3 vote to go into executive session. You can't vote during executive session, so any votes on any of these matters, if you're going to vote to buy a security system, or you're going to vote to fire the superintendent, or whatever it is that you're going to do based on those executive session discussions, you need to vote in public session. You can invite in anyone needed to provide testimony or opinion, but you do not want to create what we call a second audience. One thing I'll just make sure everybody's aware of is we had a case last year involving a school district, and the issue was that the superintendent went into executive session, which is very common. However, in this case, the superintendent did not offer any thoughts at all, any input, did not answer any questions, did not participate in any way. And we ruled against the district and said it wasn't appropriate for the superintendent to be there. So that doesn't mean that you can't have your superintendent there. In most cases, you will have your superintendent in executive session, and it's fine. But it really needs to be that they're there to assist you. If there's a situation, where you don't need the superintendent, then they shouldn't be there. They should only be there if they're participating. The hearing officer in that case had a good thing she said at our commission meeting, and that is executive session is not a spectator sport. So people that are there besides the board should be there because they're participating. And if you don't need them anymore, they've given you their input, and you're deliberating, I would say you should ask them to leave while you deliberate. What if a board discusses things in executive session that were not listed on the agenda? How should this be addressed? So if the item is not on the agenda, then I don't think you could go into an executive session to discuss it. There's a couple of things that you could do. If it's a regular meeting, you can add something to the agenda, and then you could go into an executive session. But generally, the item should be on there ahead of time. Now, you don't have to specifically say on the agenda whether or not you're going to do an executive session. But if the item is not on the agenda, unless it was voted on to add it, then I don't think they could proceed with an executive session on that topic if it wasn't on the agenda. So when you do the 2/3 vote to go into executive session, you also want to state the reason. And when you're preparing agendas for executive session, it's important to keep in mind that you want to be a little bit more specific than just a 1 or 2 word, personnel or security or pending claims. The commission has had decisions where we have said that those 1 or 2 word descriptors are not sufficient. Now, the balance and the challenge is, you don't want to reveal, the issue that is, the points of view of the board members rather on an issue that's being discussed in executive session. You don't have to. That discussion is privileged, right? It's not there for the public. But the topic is fair game. So the way to think about it is, if you have a disciplinary matter involving a teacher, you don't want to just put personnel matters, because that could be anything. That could be anything from hiring a guidance counselor to firing the superintendent. If we just put personnel matters, nobody has any idea what we're talking about. So if if there's a disciplinary matter involving a teacher at the high school, you could put something like executive session, discussion of the performance of a high school teacher. That doesn't tell us who it is. It just says, hey, there's something going on at the high school and they're talking about it. If you're discussing a security matter, discussion of security plan for Smith Middle School. Okay, that just tells us they're talking about a particular school. It doesn't reveal the security, secrets or tell us what's in that plan. It just says what they're talking about. So if you keep in mind the topic of executive session should be fair game, but not the specifics. If you keep that in mind when you're preparing agendas, then I think you'll be on the right track. Okay, so last but not least, with meetings, and we won't really have a lot of time to get into records. So if people have questions, contact me, or we can ask them as we come off the chat at the end. But I'll end with minutes, and then I'll open it up for questions. So what needs to go into the minutes? The legal requirements for minutes are actually pretty sparse. The minutes really need to be recording of the votes, who was in attendance at the meetings, and any who attended any executive session besides the board members. So a lot of the content of the minutes is up to you. And somebody had asked about the 7 days and the draft minutes and all that. So the minutes need to be available within 7 days of the meeting. So in most cases, they are going to be draft minutes because your board is not going to meet again in 7 days to vote on them. So they are going to be draft minutes. So do the best you can within 7 days to put the minutes together, and then whatever you have, file those. And my advice would be put them on the agenda for the next board meeting. If people want to make changes to the minutes or they want to make corrections or whatever they need to do, discuss them and vote on them at your next meeting. And then if you make changes, you could reflect that in the next set of minutes. So if we had our February board meeting and the minutes have been filed and now they're on the agenda for March, if we make changes at the March meeting, in the March minutes, you could put the changes that were made to the February minutes. I think that's the best way to do it rather than having to post two versions or anything like that. It's just to correct the changes going forward. Somebody asked about if you mention a personnel matter to discuss a high school teacher, does that mean that the high school teacher needs to be invited in? They do not have to be invited in. So the way executive session works is you have to notify the person, and then their choice is to request that it be held in open or to allow you to proceed with the executive session. If they allow you to proceed with the executive session, chances are you probably will want to hear from that person, but they have no guarantee or no right to be there. So, if there was a disciplinary matter and, I don't know, the evidence was so overwhelming that you felt like we don't even need to talk to that person. We know what they did and we know what we're going to do and we don't even want to hear from them. If that person said, they sort of waived the open hearing part, then the board could go into executive session. They could discuss the person. Person doesn't have to be there. They could come out and they could take a vote, to take any action. So the right of the public employee is to be notified and opt to do it in public. If they don't opt for the public discussion of their personnel matter, then the board may or may not invite them into executive session. They're kind of at the mercy of what the board decides to do. Are executive sessions FOIA-able? That's a good question. So the executive session provision is really about meetings. So what that means is, that records reflecting discussions in executive session are not always going to be privileged. So what that means is, if you have an executive session discussion and then you go back to your computer afterwards and you write an email to the whole board that lays out everything that happened in executive session, now you've created a public record. And that record needs to stand on its own as an exempt record. And there is no exemption for, it was an executive session topic. Now, if you were talking about a lawsuit in executive session, and then after that, somebody was corresponding with the board attorney, now that might be covered under attorney-client privilege. Or, if it was dealing with a personnel matter, maybe it's exempt as a personnel record, dealing with a certain issue. But you want to be careful about executive session because there is really no blanket exemption that says, because it was talked about in an executive session, the records are exempt. Personal notes might be exempt if you take notes in an executive session. But if somebody goes out and creates new records or starts emailing people or talking to other people or whatever they're doing after the executive session, they might create records that would be disclosable under FOI. How much advance notice would they need to be notified? It needs to be enough so that they have the ability to make the decision about whether or not to do it in public. There's not really like a specific time frame that's laid out in the statute or anything like that. So I think the more advance notice, the better, because then it just lessens the ability for somebody to say, I wasn't aware of this, executive session. They didn't notify me. You wouldn't want to email the person, half an hour before or something like that. You'd want to make sure that they're aware, as soon as the agenda gets published, if not before that. Okay, so minutes are still required even if you record a virtual meeting. We mentioned that already. But last, with minutes, just to end on that, find the balance of where you can get the minutes done on time. That's the most important thing is timely minutes. The level of detail is kind of up to you. Like public comment, for example, you don't have to list every single person who spoke in public comment and everything that they said. If you wanted to summarize, or if you wanted to generalize and say, 5 people spoke out against the budget, you could do those sorts of things. That's up to you. So you have a lot of discretion about what goes in the minutes, but you don't have discretion about when they get filed. That is, required within 7 days. So that's everything I've got on meetings. If anybody has any questions, either through, I don't know if people can come off the mics with how this is set up, but you could either put it in the chat or there's the question and answer function. I saw some of the people, filed them under there. So we do have, I think we're through 1:15, but I wanted to save some time here if anybody has any other questions. either put them in the chat or Q&A, or if you can't come off or whatever you'd like to do, happy to answer any questions that anybody else has. Regarding records created after executive session, does that include actions by your lawyer? So a decision was made in executive session to have the lawyer write a letter. Is that okay? So the letter from the lawyer, that might, depending on the content of it, that might be exempted. If you go into executive session and you have a discussion, let's say with your board attorney, and you're asking for legal advice, and then about a pending matter, and then the attorney turns around and sends the board an email, that email is protected from disclosure because it's attorney-client privilege. So it doesn't mean that, everything that reflects executive session is automatically going to be public, but it needs to stand on its own as exempt. It needs to be attorney-client privilege. I'll skip ahead just because we're talking about it just so you can understand. This is a list of, not comprehensive list of some of the exemptions in FOI. So if the discussion surrounded some of these topics, then, they might be exempt because of that, not because, not because it's exempt because it was from executives, because it was born out of an executive session. They would be exempt because they stand alone on their own as, exempt under a particular statute. What if he's sending a third party a letter? Then I think somebody could request that letter. So if you meet in executive session and then you give direction to the attorney to send a particular letter, depending on the content of the letter, if it is not protected by attorney-client privilege, then somebody could ask the district for a copy of the letter that the attorney sent. So again, it's the same thing with caucuses. Executive session and caucuses pertain to meetings. It's basically saying, giving you an allowance to meet in a way that otherwise would ordinarily violate FOI. It does not address records. So any records have to stand on their own as exempt, based on one of these things here. Is it pertaining to pending claims or litigation? Is it a preliminary draft? Is it personnel matters that would be an invasion of personal privacy? Is it related to collective bargaining strategy or negotiation? So that could be something that would be exempt. If you meet in executive session and then you instruct the attorney to engage in some kind of negotiation with a union about a collective bargaining matter, that might be exempted. So it doesn't mean that everything you talk about in an executive session, if it spills over into a record, it's going to be disclosed. But it just means that the exemption can't be, oh, it was executive session. The exemption needs to be, it's a security risk to disclose this. It's a attorney-client privilege protection. It's related to a pending claim or litigation, whatever it may be. If records were requested for school security plans, is that exempt based on being a potential security risk? I think it probably would be, not without knowing everything that's in the plans. I imagine there's probably reasons school districts wouldn't want to release that. And the way that it works with executive or with the security exemption, just so everyone is aware, it is not just that you get to claim that and that's the end of it. You have to go consult with somebody else if it's a matter of security for cities and towns. You go to the state police and they would help to make that determination. And if they agree, then they would say, yes, you don't have to disclose that. Can a Board of Ed member record the executive session and not let the other board members know? That is something that's not really contemplated in our law. It's not really addressed. Couple things with that I could see being issues. One, I think certainly people would be upset with that if they didn't know about it. And two, when we're talking about records, that's an example where now you've got a recording of an executive session that somebody might be able to request under FOIA, and it would not be exempt just because, oh, it's from an executive session. So I think a lot of times that might be a reason not to record something is because now you've created a permanent record of that executive session that might be available under FOIA and it may not be exempt. One thing I'll also mention, just because we're talking about, recordings and this kind of coincides with, with personal devices, I think this is important for everyone to know too on a Board of Ed. This is the definition of what a public record is. And I'm not going to read it. You've got it up there on the screen. It's really anything, dealing with the public's business. Nowhere on there do you see anything pertaining to the device. So what that means is, and naturally you kind of have to do this if you're on a Board of Ed, you are probably using your personal cell phone and maybe your personal email to conduct your Board of Education business. So those messages and those emails and text messages, if they pertain to board business, those are public records that are available under FOIA. It doesn't mean that somebody gets to go through your phone, but it means somebody could, let's say there was a threat at a school, somebody could say, I'd like to see all the text messages between the superintendent and the school board chair, from that day. And so if they were texting back and forth about what was happening, somebody could request those text messages, and then that might mean that the school board chairperson has to go through their phone and see if they have anything that would be responsive to that request. It doesn't mean the public gets to go to your phone, but it means you might have to retrieve text messages or retrieve emails. If they deal with matters of public business, they would be public records that somebody could request under FOIA. You mentioned before that if a person doesn't request specific documents as an FOI request, but lists tons of questions, we don't have to respond. That's correct. Under FOIA, it's about requesting records. It's not about answering questions. Now, that doesn't mean that you don't want to, you don't have to respond, but it doesn't mean that you might not want to. I think as an elected representative, if somebody has questions, you want to try to probably help them get answers. But where it comes into play is somebody can't file a complaint with us because they weren't happy with the answers to your questions. If somebody keeps peppering you with questions about the budget or something, and you're getting tired of answering them, you could say, hey, come to a meeting and you can hear us talk about it. But if they make a request for records, you need to make sure that they get the records that they've requested. So that's the difference there. If somebody's asking for budget documents, make sure they get the documents. If somebody is, arguing with you about your priorities, that's a different story. If you want to go back and forth with them, you can, but it's not required because answering a question is different than providing a record. So you just need to be careful there about, what are they asking for? Are they asking for records, or are they, asking me to make judgments or answer questions or that sort of thing? Are there rules for citizens identifying themselves during public comment? You could set whatever rules you have that you want. We have one citizen that never identifies their name or address, even when asked. So you could prohibit somebody from speaking if they won't give their address. You can set your own rules for public comment, and you're in charge of enforcing those. So if somebody refused to give their address, you could say, we're not going to let you speak until you give your address. That would be okay under FOIA. There's no implication. I think, this is sort of outside of my FOIA hat, but my view is, look, if you have rules, everyone should play by the rules, right? If the rule for public comment is this, then I would say as a board, you could tell people that's what the rule is. If you want to comment, this is what you have to do. I don't think asking people to get their name and address is overly, burdensome. I've had some people who have asked about, well, we don't feel comfortable identifying, our address and that sort of thing. But, the board is allowed to set that rule. And, again, this is not me speaking as FOI, but I find that when you start to make exceptions to the rule, then it gets harder because then somebody else is going to come along and say, well, how come you let that person do this? And now I have to do this. And so the more you deviate, the harder it can be to get other people to follow. Are board members allowed to tell non-board members things that were discussed in an executive session? Again, it's not something that's contemplated by our law. I think most people assume that what happens in executive session stays in executive session, but if somebody, speaks about what happened, it would be up to the board, to take action against that person if they felt it was appropriate. There's not a law being violated by somebody, blabbing about what happens in executive session. However, I could see why board members would be upset. And it's a good way to get yourself, ostracized from your fellow board members. But, legally, there wouldn't be any kind of law being broken, and it's not addressed in the FOI law. Can you require that speakers in public comment be a town resident? Yes, you could do that. You can't prohibit, folks not from the town from attending, but you could say, comment is limited to residents, and that might be why you ask people where they live, right? Because you want to make sure that, you're only offering public comment to to people who live in town. Or, you could say, you could do something where, the first however amount of time is limited to people who live in town, or, whatever you want to do. I know sometimes with school boards, you might have teachers who don't live in town who might want to comment. So, sometimes that's something that you have to think about. But again, public comment, you can set any rules that you want. That's up to you. I think we're starting to slow down with questions, or at least I haven't seen any new ones. So I'm just going to go back to the beginning. And, if there's anybody who has any other questions, or if, I addressed your question, but you are looking for something more specific, and I know there were a few people that I mentioned, there's some cases and things that I could send you, like somebody had asked about the grievances, and that's a very specific thing. So it's hard to just address it, on the fly. But I do have some information on that I can send out. So there's my email and my phone number. Please feel free to reach out if I can be of any assistance in the future. Um, is there a slide to confirm that info should be redacted on records requests? I would say contact me if there's a specific request. One thing I didn't mention in here is FERPA. FERPA governs a lot of disclosure of school records. So, you need to be aware of FERPA, and FERPA does preclude disclosure of identifying information about students and student records. So there is an exemption that covers that. If you have questions about other issues, send me an email and we can go through that. Robo emails, FOI buddy type requests, do we need to comply? I would say send me the request and I can take a look at it. Just because it's an automated request, doesn't mean you can ignore it. But with some of those, those requests, they might be asking for things that you don't have, or they might be asking for it in a way that would require research, which is also not, you don't have to do research to respond to an FOI request. I did send the slides to CABE, so I think they've got them and can send them out. If you can't get them, you could just email me and I'll send it to you. And then the last thing I just wanted to mention is that we really kind of zipped through this today, but if maybe you're here, but you've got other board members who weren't able to make it, I'm always happy to come out and do a presentation in your town, even at one of your board meetings if you'd like me to. And we can get into more specifics about issues that might be percolating, in your community. So if you would like me to come and do a training session, again, I'm happy to come in person, happy to come in the evenings. I really try to be flexible and go wherever I'm needed. So just give me a call or send me an email if you'd like to set something up, individually for your board in your town. I'm always happy to do that. With that being said, though, I don't think I see any other questions. So I really appreciate, the attendance. And as I was said earlier, when we were, getting going, before we started, I always appreciate these sessions because it's a good way to touch a lot of communities all at once. But I'm always happy to come individually and follow up. Would a training session with the full board be considered a meeting and need an agenda? I've done them as a public meeting. I've done them not as a public meeting. I think if you want to have a robust back and forth discussion, I think it's better to do it as a meeting if you're going to have the full board there. Just because then there's no, then you're not restricted on what you can do versus if it's not a notice public meeting, I think I would be able to deliver a training, but I think it would be, what would be more concerning would be if the board members wanted to start discussing things or asking questions back and forth with myself or other board members. You might get into discussions of board business. So I think if you want the full board to be there, notice it as a meeting and I could happy to come out. Can we do another meeting with more info on records requests versus meetings? Yeah, absolutely. When I come out and do the presentations, I usually cover both. It can go about 90 minutes. So we just had a lot of questions about meetings, and I know that was mostly what today was focused on, given the audience. But I'm happy to follow up if you have a specific question or come and do a presentation. And we can make sure we touch on the issues with records requests as well.
Great. And we are certainly happy to do a follow-up webinar with you, Russell, on the records requests to reach that broad audience as you were just talking about. But thank you so much. This was a lot of information packed into a short period of time. And I hope that all who are here realize the great resource that you have now with having Russell's phone number and his email address and having heard this presentation. So Russell, thank you so much for being with us. And thank you for always being so agreeable when CABE reaches out to do a session for various audiences. Thank you to all who attended for taking an active role in your own professional development. No one goes to school to become a Board of Ed member. So you really do need to take advantage of these opportunities. And it was great to see others, superintendents and superintendents administrative professionals involved in this meeting as well. So on behalf of the CABE board and the staff, I want to thank all of you and wish you all a wonderful afternoon. Thank you.